Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. In the movie A Few Good Men, Colonel Jessup, played by Jack Nicholson, tells the young JAG officer played by Tom Cruise that he can't handle the truth. I've often felt that line could have been used in almost any case I had been involved in because the truth, while it sometimes sets you free, at other times locks a door behind you. Truth is an interesting concept from the start. Truth is objective and binary. A statement is either false or it's true, correct? Well, that's what we think, but is that really correct? Some statements can be factually true, but in context, a lie. Consider the situation I read about in a short story several years ago. There was a group of friends who got together to help people solve mysteries. And this was a series written by a famous mystery author. And they were approached by a man who was under suspicion of a double murder. And he wanted them to help him prove that he was innocent. The rules of the exercise for the group that solved these mysteries was that they could not ever reveal to anyone what they learned inside the room where they held this little meeting. So the man came in, opened up his briefcase, and took out his calendar and his other exhibits, and he told his story. And he finished with the statement, something to the effect of, "I did not kill Bill or Tom, and I'm offended somebody would say so." As the group of amateur detectives worked the problem, they explored each of the potential suspects that their friend named and eliminated all of them. That left only the suspect who came to them to prove his innocence. Again, he told them, "I did not kill Bill or Tom." Then the oldest and perhaps the wisest member of that group stood and pointed a bony finger at the man and said, "Did you perhaps kill Bill and Tom?" The man closed his briefcase, stood up, and reminded them that they could not reveal what they learned. Then he walked out. In that case, truth was a matter of linguistics. But sometimes truth is a matter of subjectivity. For example, I happen to think the Kia EV6 is a far better electric vehicle than the Tesla. That is my truth, right? My truth. But it's a matter of subjective truth. It's not objectively true because many people could not use that vehicle and have it meet their needs. In the Middle Ages, there were all kinds of methods for discerning the truth, most of which were witness unfavorable, and all of which were brutal. In one test, a person who was thought to be lying was cast into a body of water, and if he sank, he was telling the truth, and if he floated, he was a liar. Apparently, no one took notice of the fact that a person was absolved of a minor sin of lying by losing their life, while someone who was guilty of lying was chastised and let live. It seems like a really odd approach, but then again, logic was not a big thing in the Middle Ages. Another test was trial by combat. The person doing the accusing and the liar would battle it out with swords and shields, and usually it was a fight to the bitter end. It would be hard to discern the truth simply by who lived, since combative skills do not correlate to truth-telling. Throughout the years, men have tried different ways to get to the truth. Sodium pentothal and benzodiazepines tend to reduce inhibitions and may result in truth-telling. But the use of these is not admissible in court. The lie detector, which does not detect lies but rather measures physiologic properties, has also been used and has been dismissed from the evidentiary pool of potential sources of evidence by the Supreme Court. Hey folks, please excuse the interruption, but let me ask you if you would, if you haven't already, please subscribe. And if you would, hit that like button and maybe even leave a comment. That tells YouTube that this is a valuable video and they'll refer it to more people. It helps me out a lot and I appreciate it. Thank you. The reason the lie detector has been dismissed as a potential source of evidence by the Supreme Court in criminal trials is that, unlike a voluntary confession properly obtained, the truth or dishonesty detected by the lie detector depends entirely on the subjective interpretation by the examiner. There is a story, which is supposedly an urban legend. I have not been able to find a validated example of this or a recorded instance of this. But the fact is that, for the most part, when police use a polygraph, they use it as a way to convince the examinee that they are lying and that the state knows that they're lying. It becomes essentially a little acting class where the examiner asks questions and then goes, I don't know about that answer. Let me ask that again. Maybe you didn't hear me quite correctly. Did you kill Bill and Tom? That sort of thing. And then at some point, they will, they'll change their story, and now the detective has them on the hook. As I said, there's an urban legend about a detective who hooked the wires from the polygraph onto the Xerox machine in the police station. And every time the guy answered a question that they thought he was lying about, they'd push the button on the Xerox and out would pop a paper that said he lied or lies or lie or whatever it said. And they would show it to him, and as a result, they got him to change his story and eventually got him convicted of the crime. It is essentially an exercise in duplicity that is designed to elicit some kind of confession on the part of the examinee. Now, the lie detector is far from the gold standard, and the reason I say that is because Aldrich Ames, who spied for Russia for decades, was polygraphed numerous times by the FBI, and he was never revealed to be spying. Sociopaths who have no conscience also beat the lie detector and are one reason why serial killers have sometimes eluded the police. Depending on who you talk to, there are dozens of ways of detecting lies. Blink rate, agitation, closing your eyes when you answer a question, micro expressions, people who kind of flinch when you ask them a question, neuro-linguistic programming, looking up and to the left every time you answer a question. All of these are used either together or separately by those who are searching for the truth. But the problem is, like the lie detector, they are completely subjective, and they may be subject to the bias of the examiner. Now, there is a famous quotation from John Henry Wigmore, the man who literally wrote the book on evidence, that goes like this: "Cross-examination is the greatest legal engine ever invented for the discovery of truth. You can do anything with a bayonet except sit on it. A lawyer can do anything with cross-examination if he's skillful enough not to impale his own cause upon it." Now, lots of lawyers quote the first sentence from Wigmore, but they tend to ignore the second. The famous lawyer Irving Younger has said that more defendants end up in the penitentiary due to bad cross-examination than any other part of the trial. In the hands of a skilled cross-examiner, a witness prone to false testimony will usually meet his match. He or she may not break down on the stand and confess like pretty much every bad person on the show Perry Mason, but you can count on a perceptive jury seeing the truth and determining who to believe. For me, cross-examination is the only real lie detector, and it depends on a lawyer skillful enough to exhume the truth from the graveyard of lies a person will tell. Everybody lies to their lawyer. Everybody lies to the other guy's lawyer. It requires a lawyer, if you're going to do a cross-examination, to know all the facts, have all the prior statements of the witness, and have them broken down by issue, have a coherent plan for attacking the truth-telling. It isn't easy, and it requires a great deal of prep. As a lawyer, I've been lied to so many times I couldn't count them all. In one case, a pediatric intensivist in Grand Rapids, Michigan, was an expert witness for a physician who was on trial for medical malpractice. This doctor had missed all of the classic signs of hyponatremia, which is a condition of low sodium in the blood. Over time, it had caused brain swelling and the death of a sweet little 2-year-old girl. Now, in a medical malpractice deposition, you go straight to the doctor's opinions. Usually the opinions are based on the facts in the case. In that case, a full liter of salt-poor solution had been infused into the child. The doctor chose not to believe that, and so his opinion didn't rest on that fact. His opinion was the child had suffered from a very rare syndrome called the syndrome of inappropriate antidiuretic hormone, or SIADH. After getting that opinion, pointing out that the pathologist didn't see it that way, the doctor's response, he wasn't there. My response to him, you weren't either. I asked him how many cases of SIADH he had seen in 2-year-olds. None. How many in pediatric patients in the ICU? None. How many had he read about? None. Had he ever even seen one case in a patient? Yes, an 87-year-old man at the end of life. 2-year-old, 87-year-old, I don't know. I think there might be something wrong there. At any rate, there wasn't much need to go further after that. He knew he was lying. I knew he was lying. But to quote a line from Charlie Daniels, I just couldn't resist the fun of chasing him once just around the parking lot. I asked him ICU questions about pulmonary medicine. Now, this guy is a pulmonary intensivist, or pediatric intensivist, I'm sorry. This guy is a pediatric intensivist. He should have known how to calculate shunt. He did not. He should have known the alveolar air equation. He did not. He couldn't tell me several things that made him look really bad. Now, the guy never came to trial, no doubt wishing at that point that he had never signed on because he knew, I knew he lied. He was willing to step up and do the wrong thing for the wrong reason. I felt sorry for him, but more sorry for his patients. But if I'm being honest, cross-examination is just as subjective as any of the other methods, because bias, particularly implicit bias, and a willingness to be led by emotion all contribute to jurors who are more than willing to get even with that criminal scumbag who, fill in the blank, beat his child, hit his wife, or killed his lover, right? The DA's job is to make the jury mad, because when people get angry, the truth of the matter is they stop thinking logically. Now, the criminal defense attorney's job is to make the jury mad at the DA and the police, and that's what they do. I think you'll see that in the YNW Melly trial. And it becomes a contest between whether jurors will act on emotion or on evidence. And that's what really, in pretty much any trial, it comes down to. Are you going to act on emotion? Are you going to feel sorry for, the lady who lost her husband? Or are you going to look at the evidence and conclude that nothing the doctor could have done would have made a difference? It all depends on the jurors and whether or not they are willing to put aside this willingness to make snap decisions on the basis of emotion. So that's what I have for you today. Hopefully you found this interesting, and if not, I'd really appreciate your comments to that effect. Thank you very much for watching. If you have the opportunity today, it would be a really good thing if you could do something nice, something kind for someone. Open a door or help somebody with a load. Anything you can do to make somebody's life better will inevitably make your life better as well. So that's what I have for you. Thanks for watching. Catch me down here at the beach again tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.